primarily when I talked to Tom about addressing this meeting, it wasn't my intent so much to give a presentation, but to be a resource to answer questions, and really good turnouts for this meeting, and I did have an opportunity to sit at dinner and listen to a lot of different stories, so I can anticipate questions coming from a lot of different directions under the law. So Tom and I spoke, and he's willing to help moderate some degree how we handle this. Hopefully we can, as we address questions, keep them kind of focused on one topic area for a while and then move to another, so that we're not jumping around a lot.
Let me start. There was I don't remember who, I took some notes, but this whole issue of folks who are looking to modify their placement due to moving, and so getting into the district, plus the issue of moving away. Somebody had a South Carolina issue of moving away, and there's specific complexities to that, plus just sort of the moving issue, if you could address some of that. And if whoever had those specific questions, go ahead and ask them in the way you would prefer to. Who was that?
What question I have? One question I would like to ask, as I read the law, it says you cannot use marriage as a reason to move.
But I think you're thinking about marriage in and of itself cannot be considered a substantial change in circumstance.
A remarriage.
Remarriage, right. But, I mean, it can be a subtle part of substantial change of circumstances, and somebody mentioned something dramatic, change of circumstances or something. The formal term is substantial change of circumstances. And most people here tonight, from what I can tell, have a judgment. So if you're going to change something, you're in the modification zone. And modification requires, there are two periods for modification. There's the first 2-year period when you have to show substantial evidence that it's necessary to protect the children from physical or emotional abuse. Very high standard, very hard to accomplish. After 2 years, you have to show there's been a substantial change of circumstances. You have to defeat a presumption that it's in the best interest of the children to maintain the status quo. And once you've done that, you return to the same position you were in when you first went through the process, either through divorce or paternity proceeding, and the court would determine what's in their best interest. So the court, the legislature specifically said getting married in and of itself does not constitute a substantial change of circumstances. Now for the person here tonight who is going to move from one side of the county to Cross Plains, that is one of the best types of substantial change of circumstances you can find, because it's real easy to identify, it's real easy to explain. You're going from being a long way from your kids to being close. It really gets you through that first hurdle, and it can be a real good strategy. In fact, if you're talking to people who are in the early stages of divorce and things aren't looking good for them, they're almost better off to be. I mean, we have had this strategy once where we had a client living in Milwaukee and the divorce was in Madison, and we said, gear yourself up for 2 years from now. You move to Madison, you'll have a substantial change of circumstances. Prepare yourself over that 2-year period to do it. So that's a great set of facts for you. The other side of this is your son and others here tonight. I think you mentioned your wife moved to South Carolina, and here's the rub in all of this. In this country, everyone is entitled to live in any state they want to live in. You have a constitutional right to go wherever you want to be. The court has the authority to look after your child. So the court can say, you can move, but you can't take the child. reality, that just seldom happens. And I think, Tom, you were talking about parents having, less than 50-50. It's almost not going to happen that they'll save the child from moving.
Yeah, but a 50-50 case, that changes the equation, doesn't it?
It does. I mean, some people say, I can't have 49% because I won't be in as strong a position. And I don't think you have to worry about things like that. I had a client once who had every other weekend, and then he saw his kids 3 nights a week after school for a few hours. Mom meets some guy in Mississippi, gets married, decides to go down there, and the court said, well, you can go, but the kids stay here. So she stayed.
All right, so Tom here, it's Tom, right?
Yeah.
If he had 51% of the time in the exact same circumstances where his ex wants to move to South Carolina, she would not be in a position to take the child because she's no longer custodian, right?
I don't think those minor nuances are going to make much difference. If he had 70%, then she would have a real hard time taking the child. But the problem is what we see a lot of under the current law is when parents live that far apart, there's school parent and there's summer parent.
Yeah. Peter?
Yeah, just when this all happens, when there's the turmoil of the relationship breakdown, when you're fighting to keep your marriage together, but all of a sudden the divorce papers arrive, and there is chaos because everything is unknown and everything is fearful. How important is that first temporary order within the first month of when you were filed with divorce papers?
It can be exceedingly important.
So,
that is probably one of the most important hearings that you'll have.
So, and what type of order typically gets given, and in that time when you don't understand what's happening, when that order is set, and what would be a typical order, the question, is it game over?
Well, it doesn't have to be, but it sure sets the stage. And changing financial things after a temporary order is not particularly difficult, but changing placement can be very difficult because the system wants to maintain the kids in the lifestyle they're used to. So they set it up on a temporary basis and then they don't want to change it.
So within a month of being given or any person giving their divorce papers, if a temporary order of every second weekend and one night through the week was set, then you're done. You just
well, you're not done, but you're in a more difficult situation than if you had 50-50. But on the other hand, you really, if you get one overnight during the week and every other weekend, you're really only one overnight off of 50-50.
And in order to achieve that extra overnight, how litigious does it become and how expensive does it become?
It depends on the other side and how much they want to fight. And the players. It's always, who are the players? Guardian ad litem and social worker. Now each county is different. In Dane County we have Dane County Family Courts and Counseling Services, 6 or 8 social workers. Waukesha has a similar agency. Some counties have none. And so Rock County basically relies on a guardian ad litem to make a recommendation. But those players are crucial to how the decisions are made. And one of the most important things is to become a friend of that person, to make them like you, develop your personality.
What is that? What are we talking about? The guardian ad litem?
The guardian ad litem, if there's a social worker who is going to make a recommendation.
Can I ask a question on this guardian ad litem? First of all, I think you're phrasing it wrong. How are you going to be a friend of the guardian ad litem? I mean, first of all, there's no transparency. Their questions can be extremely biased. And there's no connection there. There's no connection. I mean, this guardian ad litem asked me for my dog's health records based upon my ex crime